Let us discuss the matter. I took sooner than looking to sorting out the matter. Now we are discussing what is the sound? Now that is discipline. This one. Then what's the matter? Maharashtra. Of the same issue. Then he had suppressed this. Going to 84. There has to be judicial. That is your problem, but that means the prosecution is still right. Unless you can show that there is a judicial order by which you have been discharged or you have been acquitted. Please, Lordship.
Yes, the point.
Lordship's indulgence to move an unlisted matter, Millets.
Regarding?
Millets, this pertains to Millets a forceful eviction. What had happened, Millets, is originally we had filed a suit in respect of a shop room saying that, Millets, I should not be evicted without due process of law. Respondents appear, Millets. They say they give an undertaking before the appellate court saying that we will not evict you without following the due process of law. Subsequently, Millets, they file a suit against my manager, where we file a written statement bringing on record that he's the manager, has nothing to do with the shop. They file an eviction suit against me. In the meantime, what they do is, they enter into some kind of an agreement with the manager, where they show the manager has handed over possession of the shop, and they take over the shop, change the entire nature of the shop. We file a fresh suit before the learned trial court, bringing on record that this has happened. I'm being forcefully evicted, and there is collusion between the present owners and my manager. Trial court does not interfere, I go before first appellate court, bring the same on record. First appellate court says that I'm not touching upon the merits of the matter. Trial court to dispose of the matter within 2 months. In the meantime, the entire shop is gone, the stock and trade is gone, the signboard is gone, everything has been changed.
So what's the urgency now? Everything is gone.
Your lordships will kindly appreciate, third party rights are being created,
You can get it on time before it's already filed.
In the process of being filed, I'm grateful to you.
My lord, item number 46, my lord. Can it be taken up next week, my lord? Any day next week, my lord. 46. Just need to complete the instruction, my lord, in this matter. This is about school managing committee, my lord.
Who's the other side?
My lord, I'm for the petitioner, my lord.
You've informed the other side?
I will inform them, my lord. They are not here at present.
After 1 week, my lord.
Your lordship, recommendation number item 48.
Number?
48, your lordship.
48.
Lordship, in this matter, one of my senior colleague from Delhi, you will argue this matter. I pray for 2 weeks' time, Your Lordship.
Senior colleague from Delhi. What's the matter about?
This is a contractual teacher's claim for regularization, Your Lordship.
Senior colleague from Delhi?
Yes.
Who's
One
senior
of
colleague
my
from Delhi?
senior friend.
You can argue it. You're for the petitioner?
Yes, Your Lordship.
Well, okay, 2 weeks, yes.
Your friend.
Your Lordship, I beg to mention item number 38.
Why?
Your Lordship, as conducting counsel learner DSGI is out of station. If we can have it sometime next week, Your Lordship.
After 1 week, yes.
Your Lordship, I also beg to mention item number 45.
No, 2 weeks, yes. He's out of station, yes. You're there, Mr. Poya?
Yeah, I am for the respondents number 2 to 5 in this.
Yes.
This is item 47, 47. Item number 47.
You don't need. Why? Who's arguing with? You arguing it? It's 47.
Yes, Your Worship.
What's the reason?
I'm not well.
2 weeks, yes.
Obliged, Your Lordship.
Yes, Mr.
I
Sahai.
beg your leave to mention items 23 to 35 and items 42. These are
Item?
the DCRG matters, the pension matters.
23?
To 35. 23 to 35 and item 40. These are those DCRG matters, Lordship. I have received instructions late last night. So I want to place them by way of affidavit.
And item number 42?
42, yes.
42 is a different matter.
42 also, Lordship, is connected with the same issue.
No, it's not DCRG. 42 is
Sorry,
some.
42 would be different. 42 is, I stand corrected. 23 to 35 only.
22. Okay, after 1 week.
1 week.
Yes, so Mr. 25 to 32. Mr. S. Sahai submits he just received instructions and would like to place the same affidavit. Oh,
Yes, yes.
just after 1 week, yes. Yes.
Supplementary list, item number 1.
Please, Your Lordship. Lordship, in this case, Your Lordship, sir, Subir Sen is appearing through VC, Your Lordship, for the respondent.
Subir Sen?
Subhasis Sen.
Yes.
Lordship, the matter is very simple. The revisional petitioner, my lord, in this case, is a tenant of the respondent.
Okay.
Respondent, landlord, has filed a eviction suit against me. I have received notice of the eviction suit. Before the date of appearance also, landlord has disconnected my electricity. Disconnection of electricity, my lord, was on 18th of February. So naturally, yes, ma'am.
Yes.
So naturally, my lord, I filed a petition in the lower court under Meghalaya.
Now, okay, he filed a suit against you. And before you could file a statement also.
Yes, before appearance also.
Before appearance, disconnected.
He disconnected my suit, my lord, was this year itself. The date fixed for appearance was 20th.
When was the date fixed for appearance?
20th March.
20th March.
20th March.
Okay, 20th March appearance. When was the electricity disconnected?
18th February.
18th February.
Yes, my lord.
Okay.
Now, naturally, my lord, I filed a petition under the Meghalaya Urban Areas Rent Control Act for restoration of electricity. Petition, my lord, is at page 17, if lordship kindly looks.
Okay.
Just the cause title, my lord, in the matter of petition filed under section 6 and section 7 of the Meghalaya Urban So-and-so Act, read with section 94 and section 151. Based on this petition, my lord, order was passed by the assistant district judge. That, my lord, is at page 24.
Page 24.
24, my lord.
Okay.
24, my lord, is order dated 22nd February 2023, passed by Assistant District Judge. Operative portion, my lord, page 26. Page 26, the last paragraph, if I can read. The opposite party, that is the landlord, is hereby directed to restore the electricity connection in the rented premises, and the petitioner is to pay the electricity bill as earlier, and in the same manner to the opposite party, pending final disposal of this miscase. Issue notice to the opposite party, steps by petitioner, fix so-and-so, 20th March, for show cause and hearing. So, my lord, very clearly, this was an interim order, because the ADJ court would have appreciated that the next date is very far away. I cannot sit in the darkness for so long. So it was an interim direction to restore the electricity, number one. And number two, show cause hearing has been also ordered.
What happened on next date?
Now, next day could not be reached, my lord. The respondent filed an appeal against this order before the district judge under Section 8 of the Rent Control Act.
Section 8 of the Rent Control Act.
Yes, my lord. Now, district judge, and this is the only point I'm placing before my lord. District judge admitted the appeal, allowed the appeal, disposed of the appeal, set aside the ADJ's order without issuing notice to me. That is the limited grievance I have that I am placing before my lord. District judge's order, my lord, is at page 32. If lordship,
possible.
It is very obvious, my lord. Page 33, if lordship sees the second last paragraph, heard learned counsel for the petitioner appellant.
33.
Yes, my lord. Second last paragraph on page 33. Heard learned counsel for the petitioner appellant, landlord, who submits the learned court while granting ex parte order under challenge without following the procedure as contemplated under section so-and-so, so-and-so. So she heard the appellant, the respondent. Next page, Your Honor, lordship, third paragraph. Third paragraph, it is apparent.
Yes.
It is apparent on the face of the record that the provisions of Section 7 of the Meghalaya Urban Rent Control Act so-and-so has not been complied with while granting ex parte order. So there was some observation that apparently procedure was not followed. I am not on that, my lord. I am not on the merits of that. Since the non-compliance with the provision is apparent on the face of the record, this court is of the view that the matter can be disposed of at this stage only, without issuance of notice. Operative part, my lord, next page. Second last paragraph, in view thereof, my lord.
Yes.
In view thereof, the order dated 22nd February 2023, passed in miscase number so-and-so by the learned Assistant District Judge, is hereby set aside with the direction that the procedure laid down in Section 7.1 of the Meghalaya so-and-so Act be complied with, and an opportunity to show cause against the application of the tenant be given to the landlord appellant. Opportunity to show cause was given. So with all due respect, my lord, I cannot contemplate any situation where an order is passed against me, snatching away a valuable right that has been vested on me without issuing notice, without hearing me, my lord. That is the limit grievance I have. I have submissions on the merits also, but my lord, I am sincerely confident that all that is not going to be gone into. My friend for the respondent...
the lower appellate court meant that no final orders have been passed for reconnection or hearing.
It wasn't a final order, my lord. My lord has seen it wasn't a final order. And even if it was, even if there was some suspicion in the mind of the district judge that it was a final order, yes, issue notice to me, my lord. Issue notice to me as I had submitted. A valuable right had been vested on me, rightly, wrongly, by the lower court, my lord. Now, this valuable right, judgments are there with me today from the Supreme Court and various high courts, that it is the right to receive electricity, my lord, is a right under Article 21, connected to right to life. So a vital aspect, element of right to life has been snatched away from me without hearing me, my lord. So, my lord, I would humbly submit that the illegality in this order is manifest. It is apparent. No extensive hearings.
So what happened, because the direction here is that within 3 weeks.
Within 3 weeks, my lord. And what is happening?
6th of March.
Yes, my lord. Now, what is happening in the lower court is that on 20th March, there was a hearing conducted. We requested, please pass an order, one way or the other, because I am sitting in the darkness. Instead of passing any order, lower court, ADJ's court, fixed the matter for further hearing on 3rd of April for submission of certain documents by both parties.
That was?
This week, Monday.
So what happened Monday?
We submitted documents. They asked for time. They were granted time. Matter is now fixed on 24th of April. Lordship, electricity was disconnected on 18th February. Now, till 24th of April, under any circumstances, I'm in the darkness. Beyond 24th, it is
Yes,
any
Mr. Sen.
it is anybody's case, my lord.
Yes.
So I am only praying, my lord, that this matter can be disposed today itself. My friend is appearing.
Let's hear him. What
Very
he has to say. Maybe he has a different story to spin. Yes. Yes,
Thank
Mr.
you,
Sen.
Lordship. Absolutely a different story.
Yes.
Firstly, we are appearing today. We haven't been served with a copy. Lordships can at least direct the petitioners to serve us a copy. Matter can come up tomorrow. I can address Lordships on the issue.
Very well. But as I
And
said,
as far as the question of disconnection is concerned, well, the disconnection did not happen on the 18th of February. It happened in 2020. It's a completely
Happened
different
in
story.
2020.
Lordship, it is
The
the
disconnection of the
it is the
2020
pleaded case.
after the opening of the first lockdown.
Yes.
Lords, I can take Lordships to the provisions of Section 7. If Lordships will kindly have Section 7 for a moment.
Lordship, if you are doing the hearing, very well. But if he wants a copy, I'll supply a copy.
No, you will have it tomorrow. No sense in wasting time.
Lordships.
Yes, Mr. S. Jindal, the counsel petitioner. If you notice, Mr. Roy,
SK Roy.
President, SK Roy is present, accepts notice on behalf of the respondent.
Yes, sure.
Says, stop, Mr. S. Jindal, since praise that the matter is urgent, the matter be taken up tomorrow. Praise allowed, this is matter
Obliged.
tomorrow. That is the
Obliged.
I'll leave.
Item number 2.
We are compelled to again approach Your Lordship for the second time. Your Lordship, kindly have page 213, Annexure 12.
213.
Yes, Your Lordship. 213.
Yes.
This is Your Lordship's order. Operative part is at page 215, paragraph 5.
Yes. Yes.
So, my lord, pursuant to this order, at page 217 and 216, my lord, this 216 is the proof of filing, and 217 is our forwarding letter.
When did you file it?
This is 16th of December 2022.
Okay. What happened after that?
My lord, nothing, no notice, no nothing, my lord. We've been waiting. Now we are sitting on April.
Your Lordship was pleased to pass this order at Annexure 12, allowing the writ petitioner, or rather giving the writ petitioner opportunity to file an election petition. That has been done. We have received the election petition, and we are examining and in the process of acting on the petition. We have not issued notices. It's a fact. There is an internal communication among us, how to go about, what to do, what not. That's our business, Your Lordship. We are yet to take actions on their election petition, and this is a fact. The writ petition filed by them is just superfluous and not necessary.
No, but then he has a grievance. If he's come to court once, then he's been allowed to file election petition.
Yes, he has filed.
Now the thing is that 16 December is filed it and you sat on it.
In fact, I cannot convey the internal communication, but the appeal is with us. We will take initiative to pursue this matter, Your Lordship. It's not that.
Can we give a time frame?
Your Lordship, it so happened that why we could.
That you'll have to appoint a judicial officer also to head the tribunal. You have
See,
not done that also.
What happened is because of that general election, nobody was there. Now they have started to come. That's how we got delayed, Your Lordship. The instant writ petition, Your Lordship, in fact, is not maintainable.
We will dispose it of Mr. Philemon Nongvina, counsel for the petitioner, and Mr. PGK Kanta, special counsel for KCDC. This is the second round of litigation challenging the election of the Sardar of Maulong Sardarship, which was conducted on 14/10/2022. Results declared on 19/10/2022 and Sanad issued on 21/11/2022. In the earlier round of litigation, this court, by order dated 6/12/2022, had allowed the writ petitioner to prefer a election petition before the District Council. point number 2 with regard to the challenge to the election. Next paragraph. Mr. Philemon Omri, in a counsel petitioner, submits that in pursuance to the order of this court, an election petition was filed on 16/12/2022, but till date is yet to see the light of day. He therefore prays that appropriate directions be issued directing the respondents to take up the matter for speedy disposal.
Yes.
Next paragraph. Mr. V. Kantari Secretary Counsel submits that it is the respondents are seized with the matter right now, and process is underway for taking up the matter for disposal. Stop. What do you have to say about the time frame?
Lordship, we have to leave it open. We will try to dispose it because
with regard to giving undertaking, with regard to an undertaking as to the time frame, the alleged senior counsel prays that this may be left to the respondents, who will try constitutional submissions of the parties, and especially the standing of the special counsel. It appears there is no impediment or any reason that the election petition be not taken up and disposed of in accordance with law. Accordingly, this petition is closed, disposed of at this stage itself by the source itself, and it's expected that the matter be taken up on a war footing and be disposed of as expeditiously as possible. Yes.
We'll have to follow the same procedure, Lordship.
Item number 3.
Issues, not. Much obliged.
Yes, Mr. Wajri.
Your Lordship, my case is that I had gone to file an RTI because I was declared tainted, and everything is based on the score sheet. So I was declared tainted based on the score sheet, but I don't know this based on the score sheet.
You were what?
I have been declared as tainted teacher.
Tainted, okay.
Tainted teacher. So I went and applied an RTI. I want to know the score sheet, but the reply that I got is that we don't have that score sheet with us because it has been handed to the CBI. So I went to the CBI. When I went to the CBI said, no, we don't have it with us. After the investigation, we returned all the documents. So my case here, I just want to see
your marks.
My marks, yes, Your Lordship. That is my case.
Is that a fact? Where's the score sheet?
Your Lordship, at the moment, Your Lordship, we don't have instructions on the matter. So if I may be allowed to take instructions.
Tainted, tainted, tainted in view of what is the reason for you being tainted?
The score sheets are tampered.
Your score sheet been tampered. That's the reason.
Yes, that is the
reason. So you want to see your score sheet?
Yes, Your Lordship.
Take instructions. Yes, heard Mr. DQI in the counsel petitioner. Issue notice returnable in 3 weeks.
And for both the respondents, Your Lordship.
And as an inaugural for list after 3 weeks. With for instructions to affidavit.
Item number 4.
You receive here the petitioner is the permanent resident of Tersar Muksai village.
Petitioner is what? He's the
permanent resident of Tersar Muksai village. Tersar Muksai village. Tersar Muksai.
Okay.
And since generation they have been living there, and all along has been cooperating with the Darbar. But since the respondent number 4 became the headman in 2019, they started intervention into the private affair of the petitioner by blocking her ingress and egress to her house, and also threatened to demolish her house.
On what ground threatened to demolish?
No,
you don't know reason.
Yes, no. But the petitioner was left for no other option but to file a suit in the district conciliation. But the respondent number 4, after filing the suit, became enraged and started insulting and harassing and boycott the petitioner and her family. So the petitioner, being aggrieved by that, filed a representation before the respondent number 2 for intervention of this social boycott. But the respondent number 2 issued a notice, Your Lordship, which is in Annexure 325, Your Lordship, page 25, asking the Sardar of Himapam Smooth to look into the matter, Your Lordship. But the petitioner is not aware as to what any action.
Who's Sardar Pamsan? The same person. It's one number.
No, Your Lordship.
This number 4 is headman of Ritarsad. Now Sardar is.
He was not a party there.
You didn't make him a party.
No, Your Lordship.
Why? Yes.
The petitioner was not aware, Your Lordship, of to any action taken by the. But again, the respondent number 2, Your Lordship, issued a notice, another notice, Your Lordship, which is an Annexure 4, Your Lordship, rejecting the representation of the petitioner, stating that the matter is still pending in the court and we cannot do anything, Your Lordship. Whereas the case before the District Council and the EC is big different, Your Lordship. And after that, Your Lordship, the respondent number 2 created further harassment to the petitioner, Your Lordship, by declaring that in the event of any death or anything.
Social boycott. Yes, Mr. Contempt.
I didn't know about this. I missed. I didn't know it has been disposed of because the matter is sub judice in a civil suit. The civil suit is, the civil court is adequately has the.
Not in these matters. You see, the very reason is because he filed a civil suit there. He filed a civil suit just to protect his own property. And it always happens in the villages, they do this kind of thing. You've gone against the Darbar, we will deprive you of water. It's very unfortunate.
Now, Your Lordship, the respondent, the headman, Your Lordship, has refused to give a certificate also. And whenever the petitioner approached for signature, they refused.
We'll call him, yes. Heard Mr. Nyotana, petitioner. Mr. BG Senior Counsel is present on behalf of the respondents 1 to 3. Advice 1 to 3, no further notice called for. Notice to issue to respondent number 4 by the said AD, also a personal service. Yes, to be effected within 3 days. Stop. Next paragraph, right. The grievance of the petitioner herein is that the respondent number 4, that is headman of village Tarsad Umkse, East Khas Hills district. The petitioner instituted a suit against the village.
Against the headman.
Against this one of 4. With regard to his property. With regard to property in the village itself.
The grievances of the petitioner hearing is that respondent number 4, that is the headman of the East Khas district, to the Darbar Associate boycott to put the petitioner and his family members
through the Darbar, he's done that.
Yes,
that the respondent number 4 through the Darbar, not through the Darbar. Social has affected a social boycott of the petitioner.
In view of the fact that the petitioner has instituted a suit against the respondent number 4 with regard to the property in the village.
Please stop. If this submission is, if these statements are correct, it is very unfortunate. It's very unfortunate that this one before has resorted to such action. This next paragraph, this is matter on after 2 weeks.
Lordship, I have a suggestion. Here the main, the Sardar of
Thompson
I
he's not party, it doesn't matter. We'll get him here first and we'll see. Because these matters you need to understand, yes. This matter of 2 weeks, yes.
Item number 5.
For service report and for appearance of the respondent before.
In fact, I wanted to help the writ petitioner.
Yeah, because they can't. This has happened.
But the prayer of the writ petitioner is limited to
take action.
To take action on the representation. It's limited to that only. Now, there has to be a further prayer. In fact.
No, he didn't make anyway. That is he's the master of his brief.
He's the driver. Much obliged.
Yeah.
My Lord, this is a petition for restoration of the case, which was dismissed for default on 20th March, my Lord. It was due to the gap of communication between the writ petitioner and the lawyer that it appeared that he has appointed some other lawyer, which transferred.
What gap communication? That's your own submission, Mr. Siddiqui. That earlier counsels submitted for the court, they've been disengaged as counsels. What do you mean with you have been disengaged? You've been disengaged. What's the reason? Where have you written the reason that where you've been re-engaged?
But there were two cases of the same name of the petitioner. So that is why the communication gap was there. It was understood that another person is there. This name number Sikandar Ali, two cases were there. Another person, Sikandar Ali, was also there. So there was some confusion.
Oh, you had two clients named Sikandar Ali.
Default in appearance, my Lord. Yes, my Lord.
Yes, this case number 30 or 2023 in WPC number 477 of 2022. So this application have been filed for restoration of WPC number 477 2022 to file, which had been dismissed for default on 23/2023. 20/03/2023 between the lawyer and his client, that the matter be restored. Ms. Kharmi, any objection?
No objection, Lord.
Next part, Mr. H. Kharmi, another counsel at GA, at senior GA, has no objection to such restoration. Stop. Having heard another counsel for the applicant, and as a good ground for restoration has been made out, the miss case number 30 of 2023 is allowed, and WPC number 477/2022 is restored to file. So, this case disposed of. In the main case, in with order passed in this case, so and so. This is matter for orders on so and so date.
Main list, item number 1.
May it please, Lordship. Lordship, respondent number 3, 4, and 5 are supposed to file their respective affidavit.
For 4 and 5, I will be filing in the course of the day, Lordship. 4 and 5.
Respondent number 3 has already filed. We have already filed our affidavit.
Mr. Shati, you're for number 6. What about 1 and 2?
I'm here.
You're not filing any affidavit?
I will not file, Your Lordship. How can I just file an affidavit to defend my order?
I think that's a correct approach also. The judicial body is.
Respondent number 3 already filed, Lordship.
Mr. B. Kariam, General Counsel for Respondent 4 and 5, submits that the affidavit will be filed the course of the day. This is the matter after. When? You want to file a joinder?
Subsequent to
for a joinder
perusal
of
of the
any case.
affidavits.
Item number 2.
Applied.
Lord, I'm praying for 2 days' time, my Lord, to file my affidavit. I'm really sorry.
How many times have you
my Lord, we had, as a matter of fact, sent the...
You recalled order on 14, you filed 14 for recalling.
I've already
order.
sent the draft to them, my Lord. They informed me today that they'll be sending it by tomorrow. So,
You can't carry on like this, Mr. Thapa.
I'm
First
really
you-
sorry, my
First
Lord.
was closed, then you file a missed case for recall.
We
and
had
after-
sent the
after
draft, my Lord.
orders
There were
allowed,
some
again you
corrections
don't
to be
file
made, so...
affidavit. What is the court to do?
I'm really sorry, my Lord. Just 2 days accommodation, my Lord. We'll be filing it within the 2 days' time. They are already in receipt of the affidavit in opposition, my Lord.
Mr. S. Thapa, counsel for respondent 4, submit that due to unavoidable circumstances, the affidavit could not yet be filed. He prays we allow 2 days' time to file the same. Prayers allowed in the interest of justice, yes.
All right.
3.
Please, Lordship. Well, this is item number 3, 4, and 5 from hearing for 8 respondents. Lordships will recall this is a matter where the petitioners as contractors had done some work for the PhD department and payments were outstanding. So, aggrieved with the non-payment, they had approached this honorable court. On the 31st of March 23, payments in respect of the petitioner in item number 4 have already been made.
4.
And we communicate, Gary movement, item number 4. And we've communicated the payment fees to the counsel for the petitioner. Now, the amount that has been paid, Lordships may recall that they had originally claimed that the amount was roughly about 80 lakhs.
Yes.
But these are all running bills. Amount paid is about 1 crore 5 lakhs 11,106.
1 crore?
This notary has the receipts. 1 crore 5 lakhs 11,106.
1 crore 5 lakhs 11?
11,000?
106. 106.
100.
That's correct.
So this amount, Malaz.
They asked for how much in the petition?
In the writ petition, they did not indicated a specific amount, Malaz. But the amount of bills that were submitted was about 1 crore 21 lakhs 9,300.
Okay.
So I think there is some tax
so
reduction.
For this item number 3 and the other
3
one
and
that
5.
means
Still 3 and 5. It's
that is still outstanding. I'll pray for another 4 weeks, my lords, because I think the placement of funds has already been prayed for. Some amount of time is required.
Gary movement's been paid.
Already paid. If the petitioner's counsel is agreeable, this matter may be closed.
item number 5. That is
4.
4. Item number 4.
Prayer, may I please, Your Lordship? Prayer is.
1 second, 1 second. You see 83 lakhs 30,000
Yes, Your Lordship.
010, Mr. Who's appearing this case?
I am appearing, Your Lordship.
So you've received 1 crore.
Yes, Your Lordship. More than 1 crore.
Then you refund the other excess amount.
I have no. Your Lordship, on the request of my learned friend, I have communicated to him that whether money received or not, how much. He said, I received, but he didn't confirm me, and now onwards, still since morning.
He will not confirm with you now.
Your Lordship, what are you doing?
Yes. Letter dated 4th April 2023 has been produced before the court, indicating the fact that the petitioner in the instant writ petition has made a claim of rupees 83 lakhs 30,000 010. Payments have since been made, totaling to 1 crore 5 lakhs 11,106. Stop. The senior court advocate submits that this is as per the running bills. In this view, the matter nothing survives consideration in the instant petition, and the same is closed. Stop. Copy of the communication is taken on board and made part of the record. So we close that one.
Yes, sir.
We've got more than 25 lakhs more. The next item.
Here, my lords, in item number 3 and 5, Mr. Gautam is appearing for the petitions. I will communicate to him. The matter is under process, my lords.
Give them some more time.
Yes, ma'am.
Yes, with regard to item number
So long
4
they don't
and 5.
dispute their liability, they can
Or
take
3
as
and
much time
5. Item 3 and 5. Then the senior on place funds allowed further 4 weeks' time to receive instructions with regard to placement of funds for settlement of the petitioner's dues. Yes, this accordingly.
Item number 6. Item number 6.
In this matter, we have to file a small affidavit to clarify, my lord, what has happened to the amount. What has happened to the amount that we have received from the government? As per my learned friend, he has filed an application bringing to record the reply of the RTI, my lord. In the RTI, we have said that the amount has been utilized for salary. It was the backlog that we have cleared, my lord. And
But first that 22, 23 used for salary.
Yeah, for the backlog, my lord. Not for 22, 23.
Then RTI reply does not say that. It says that as you know.
Yeah, that is why we want to clarify, my lord. We'll file a small affidavit. We'll clarify that position. Probably there was
we
some
accept the clarification. We won't need affidavit. We'll accept the clarification.
wrong information, my lord. The position cannot be changed, my lord. Whatever money we have received, my lord, from the government, we have paid them. The backlog. So that is why I want to file a small affidavit, bring it to record, my lord. Probably that RTI was not in proper shape. It was the correct answer was given, my lord. They tried to say something else, but it is reflecting something else, my lord.
It was RTI was supplied by the chief executive officer, but how can it be wrong?
Incorrect. The chief executive officer will given.
Chief information officer.
Sometimes Mr. PT Sam also make mistake.
This is the document issued by the chief executive officer, Bakmar Municipal Court.
Well, I'll file my affidavit, my lord, within 2 weeks, my lord.
And moreover, your lordship.
But this is a letter from the public information to the joint director of urban affairs. Who's Kingston Bolwari?
He's a social activist.
No, my lord. He's not a social activist, my lord. He was arrested also in one of the extortion case, my lord. And number of cases is pending in local.
Who's the person who's come for his court?
That is why, my lord, I want to file a small affidavit, my lord, in this.
Who's Kain S. Marak?
Kain is one of the whatever maybe, because they cannot give a wrong information.
Look at this on the earlier occasion. Now we see that it's a letter from the PIO to the joint director of urban affairs. On who's this Bolwari? Kingston Bolwari.
Yeah,
This is just a social activist, my lord.
My lord, if my lord goes to the Google, my lord, and type this name, my lord, all the details will come out, my lord. Where he was involved.
I won't have that kind of time.
I know, my lord. Just I'm informing you.
Whatever may be, only claim is that because we are coming only for the salary. Because the salary is
by a paper which is obtained by someone else.
Is he an employee of the Bagmara?
No, my lord. No.
I said he's a social activist. I said
he's a society?
Social activist.
Social activist. Okay, right. Mr. S.D. Response allowed 3 weeks time to file an affidavit.
Clarifying this position.
But only our concern is that we want only the salary, lordship. October 2021 till now we have not received the salary. That is the correct position. Maybe the wrong RTI that maybe it will not be. But only our concern is they have to pay our salary.
Of course, that's your right. But I mean, anyway, yes.
Item 7.
Lordship.
Where's the affidavit?
Your lordship, we've just received the instructions, your lordship. We're praying for
When was this
3
filed?
weeks time.
16 November, your lordship.
We just give 2 weeks further time allowed to file affidavit.
Item 7 and 8, same order, your lordship.
Yes?
Item 7 and 8, same order. Obligation. 9.
Your lordship, respondent 1 to 8 are supposed to file the affidavit.
My lord, 678. For respondent number 678, my lord, my affidavit I have already sent to the department for vetting, my lord. I require 2 days time, my lord, 1 or 2 days time for filing.
Who appears in this case? Ailingwa or R. Colney or?
My lord, there are 19 respondents. So I
There are many respondents. There's only PHE and collector, that's all.
My lord, 678. I have represent 678.
Your Lordship, on behalf of respondents 1 to 5, I'm making similar prayer, Your Lordship. The 2 days time will be given, Your Lordship, to file the affidavit.
2 weeks time already been given on
My lord,
21/3.
we are only waiting. I'm only waiting for approval of the affidavit which I've sent to the corporation, my lord.
Can't carry on like this.
Your Lordship, I'm praying for 2 days time, Your Lordship. We'll file it positively by tomorrow.
My lord, it will be on board, my lord, in the period
Also
of
2 days time.
My lord, if I make a submission, it will be filed during the course of the day. It may be wrong in case we are not able to.
Yeah,
Which is
MS
why I'm
R.
praying for 2
Colney,
days.
MS Innofancy 4 to 5 and R. Colney for 6 to 8. What about who's Karmoshun for 9 to 13, 16 to 18? They are filed?
Yes, Your Lordship, they have already
They already
filed.
filed. Okay, Zarina 1 to 5 R. Colney is also aroused for the 1 week's time to file affidavits. List after 1 week. Yeah.
Obliged, Your Lordship.
Highly obliged, lordship.
10.
Lordship, I pray only one week's time.
How many times you've taken?
No, only this is the first time taking. On the last occasion, I have not taken.
First time you've taken
twice. This is second time only.
Mr. P.D. Samba prays for the Lord for the how much time?
1 week.
3 weeks time to file.
Lordship.
Yes.
Much obliged, Lordship.
11.
Please, Lordship. Lordship, I'm praying for 2 weeks' time in this matter to take instructions. We've not been able to contact the client over the
service. When did he join service?
2011, my lord.
11. How can he be regularized?
That's why I'm
working as what?
As an LDA, Lordship, in Garo Hills, where Tura.
Where have you filed affidavit?
Yes, my lord.
Yes, Lordship. It was filed on 16.
What instructions do you need?
On whether we should challenge the file afresh, or because they have put a letter, my lord, that it cannot arise. So maybe we have to challenge that letter or take other recourse. But we are not able to contact the petitioner on the phone number, my lord. So we sent a letter.
We'll expose on merits.
Lordship, we have it after
we can come back.
Lordship, I have it after 2 weeks.
These small matters, what do you do?
Lordship, we want to get proper instructions.
Okay, Mr. SK, please for the allowed 2 weeks time to obtain instructions from the petitioner on the affidavit filed by the state respondents. Yes.
Much obliged, Lordship.
12.
Much obliged.
Please, Lordship. This matter, Your Lordship, I got an instruction from the petitioners 1 and 2. They're saying that they are trying to settle the matter with a sole respondent. Maybe later, matter maybe after comes sometime for the development, because
who's the sole respondent?
It's Mr.
I am for the private respondent 4, Lordship.
So number 4.
What's the matter about?
This is regarding the payment of family pension, because this late Pitingson Sangmayi has got, he married 2 wives, Lordship. So the private respondent is first wife, I'm the second wife, Lordship. So after the death, after the expiry, Lordship, that pension was, there was...
Who's the first petitioner here? I don't know the second petitioner.
Daughter. And first is the daughter. Second is the second petitioner is the wife of second wife of the deceased.
Second petitioner is the second wife of the deceased. And the private respondent is the first wife.
First wife.
So who's drawing the family pension now?
I was drawing, Lordship, subsequent, because there is an order. The order, in fact, they have misinterpreted the order of the order of the court.
No, it is not
What does the court say?
To stop the.
Is it here?
Yes, Lordship.
There is no mis.
But I have been already releasing that salary has already
So
been.
where's the order of the court?
There is no interpretation, my lord.
1 second, Mr. Summons. Yes, where's the order?
That is, Chief.
Because we have make a miss case.
10 August 2020, Lordship. In the miss case. 10 August.
Miss case?
Yes, 2020. 2.
1 second.
The order was passed in main case, Lordship. That
no, the miss case, page 10, there's no page 10 in the miss case.
order was passed in the main case, Lordship. He filed miss case, but order was passed in the main case, Lordship.
Oh. Order dated?
10th August 2022.
Yes.
Here, my lord, it is further provided that till the next date, the respondent number 2 and 3 shall not take any step to release the terminal benefits of the deceased employee.
Yes.
Here, I have already received, and I was receiving the pension, Lordship. Because of this order, the pension has been stopped, Lordship. My friend's prayer in the writ petition is that not to release. My case, it has already been released. And my lord, if my lord kindly see the petitioner, my lord, the identity of the petitioner, that is at page 14, Lordship, his writ petition, Lordship.
Yes. For page 14.
1-4, yes, Lordship.
Yes.
This is the identity card of the petitioner number 1, Lordship.
Yes.
Who claimed to be the daughter of the pensioner, Lordship.
What's the petitioner's name?
Pakirchan T. Sangma, Lordship. Daughter, Lordship. Her age.
This shows, yes.
Kindly see, Lordship, her age 20 on 8/2008. So that pension rules provide only for till 25, Lordship, unmarried daughter. So the petitioner number 2, next page, Lordship.
Yes.
Tikna Maharaj.
Yes.
Relation's name Okul Areng.
Yes.
Okul Areng. So in his writ petition, he himself says that I am yet to establish my right, whether I am a wife or not. So before establishing my right, the respondent authorities has initiated the process to release the pension. In fact, it has already been released and I was receiving. So in the...
Have you filed affidavit?
Yes, Lordship. I filed. In affidavit, my Lord, that first pension order, Lordship, I have 3 children. That reflected.
Page?
Page 11, Lordship. Annexure 5.
Okay, yes.
My Lord, below, my Lord, down below, Lordship, last.
Yes.
In the event of death of Sri Pakistan T. Sangma, he is the pensioner, Lordship. The family pension at enhanced rate at the rate of rupees so and so. Only the following day, the date of the pension up to 7 years or 29/11/2028, whichever is earlier, and thereafter at a normal rate of rupees so and so per month plus DA and MA may be paid to Srimuti Purmali R. Marak, that is myself, Lordship. So after the date, my Lord, he died on 25th January 2022, Lordship. Then next annexure, Lordship. Release order, Lordship. Page 13.
Yes. So anyway, let's see his writ petition. How do you establish your right?
Your Lordship, what happened actually, the death certificate also they have obtained illegally, Your Lordship. To that effect, we even filed the FIR also against the private respondent. We have even enclosed. It is not a dispute. I'm the second wife of that, and the daughter of late Pakistan Sangma is claiming, Your Lordship. Both of them they are staying together.
Major, Lordship.
Whatever maybe, but the petitioner number 2 is entitled. It's not a dispute that I'm the second wife, but unfortunately, of course, there is no legal marriage. However, they were staying as a husband and wife since, and in fact, the late Pakistan Sangma died at the time when he died. It is in my hand only because respondent number was in Garo Hills only. They were staying together in Barapani.
Who was staying together?
The late Pakistan Sangma and the petitioner number 2, second wife.
But then he has a photograph of staying with
that photograph. It can be because she has abandoned long by, Lordship, and he has used it because at the time when they were living, she has taken all the document. She went to the Garo Hills, and even she was staying in Garo Hills, not Garo Hills only. And after when the Pakistan expired, then only after so many years she come back and claiming for the dead body.
When did she desert him and go to Garo Hills?
I have mentioned the petition.
Where we staying?
More than 20 years. I said, Lordship.
Then how is pension payment order with?
That's why it is very illegal. That's why
2021.
Those things we.
How can you manipulate this, Mr. P.T. Sangma? Look, you just look at page. You have not filed rejoinder also. Page 11 say. Page 11 of the affidavit. It's 23rd December 2021. The picture of the deceased person with the respondent number. Your respondent number 4.
Respondent 4. Lordship, because since this
then if you were staying with the deceased employee, then why should you take a picture with the old wife?
Lordship, since this petitioner, they said that they want to substitute me. That's why I have not gone through fully the affidavit pipe. Since
you're not ready to settle, correct? You won't settle.
Otherwise, I will file the rejoinder to this. the affidavit.
Though Mr. P.T. Sangma submits that there might be some settlement from the materials available on record, it appears that the petitioners are yet to establish their right as to the claims made therein, established after 4 weeks
Lordship.
for rejoinder.
Lordship.
Hello.
Much pleasure, Lordship.
13.
May I please, Your Lordship? Your Lordship will be filing the affidavit rejoinder during the course of the day, Your Lordship.
Yeah, MC Dakhar. MC Dakhar submits the affidavit file in the course of the day. Submits the matter for hearing after 3 weeks.
Obliged, Your Lordship.
14.
May I please, Your Lordship? Your Lordship, I have got the status report. It has been delivered. Affidavit could not be filed, Your Lordship. I will need 1 week time to file. Status report is yes received.
Submits that he had status report with regard to service of one of the 6 things been received. Stop. He please once allowed 1 week's time to file affidavit.
Your Lordship, I may also allow. Yes, I may also allow to file rejoinder to the affidavit.
And also rejoinder affidavit filed by respondent number
5.
5.
15.
Your Lordship. Your Lordship, respondents 1 to 3 have we filed our affidavit.
Lordship, here I prayed for time, Lordship, for respondent number 4. I have, because Lordship, he could not come because of the...
No further time we granted, yes.
Yes, my Lord. Several times I was granted, Lordship.
Yeah, for respondent numbers 8 and 9.
4. Only 4. I have a very limited role, Lordship.
You file.
That is 3 weeks, Lordship.
See, it made clear no further time we granted filing affidavit and amount said materials available. Stop. What only your file?
Yes, Your Lordship.
We'll decide on the materials available. What is necessary? What's the matter
I have
about?
very limited role, Lordship, in fact. Only I have received the application form. Other than I don't have any...
Then why you need to file affidavit then?
You're representing the
principal. Because as per law...
Teacher.
As per law...
8 and 9 is you append for whom?
Lordship, I have received the affidavit filed by respondent 8.
8's file.
8 has filed.
You're for 8? You already filed. Okay, then you're for?
5 to 7, for the managing.
You won't file.
Will be filing.
You pay cost. Even you pay cost. You're for number 4. Yes, by order dated 17/3/2023. This court had observed that no further time they granted for filing affidavits. Stop. Today, MS Zarinogari submits that on behalf of 1, 2, 3, affidavits have been filed. Stop. Prayer, however, is made by Mr. S. A. Sheikh and MS B. Karwan Lang. S. A. Sheikh for number 4 and B. Karwan Lang for 5 to 7 that some more time be given for filing affidavits. That paragraph, considering their prayers, the seems allowed subject to payment of 2,000 rupees each as costs to be paid to the legal service authority.
There are 2 cases. Item number 16 also, Lordship. It can be 1 Lordship at least. Item number 16 also same.
1 month?
Item number
Time
16.
granted, yes, huh?
Item number 16 also, my Lord. Same.
So there are 2,000 also there also.
Same school.
You file government.
State has filed.
16th, I have filed also, my lord. For 8.
Who has not filed?
No. I have not filed.
On 9th and you haven't filed. Yes. Sauce for the goose, sauce for the gander. You are for which Mr. Yobin?
My lord, in WPC 4 to 5, my lord. Safiqul Islam, I am for respondent number 8, my lord.
That is item 15. Order has been passed.
Number 8. 15 or 16 order? 16 is one.
Item number 16.
It's supposed to be 16.
5 to 7, not filing. 5 to 7 is file.
No, Your Lordship. Lordship, in so far as item 16 is concerned, only the state respondent has filed the affidavit.
1 to 3, Madam State respondent.
Only state respondent.
Take one file.
No, Lordship.
Okay. In this matter, affidavits have been filed on behalf of respondent 1 to 3. Stop in view of the order dated 17/3/2023. The remaining respondents who have not filed are subject to payment of rupees 1,000 as cost. But they can't make 1,000. This one's 1,000 cost.
Highly honest, Lordship.
And Lordship, I may be allowed to file rejoinder to the state.
Let them file first, pay first, and file. Still affidavit. Mr. I'm not brace was allowed so similar time to 3 weeks time to file rejoinder to the after state respondents.
17.
Yes.
May please your lordship. This case has been taken over from one of my friend. Here your lordship, with order dated 22 to 23, your lordship, the district council respondent 1 to 3 has made that they will not file the affidavit, your lordship. Now on the order 10/3/2023, when my beautiful colleague has been handling this case, he mentioned that we relying on the affidavit filed with respondent 1 till 3.
There was a communication gap.
So your lordship, if the
Who's
respondent
number 3?
1 to 3 are not filing.
Who's yes? Mr. Arsendram 4 to 6. No, listen. Client affidavit file respondent. So you're not filing. So no reliance. So that
Yes,
means your
your
case.
lordship, I need leave your from this court to file an affidavit.
Your 4 and 6. Your 4 to 6.
I'll be appearing now for in this case.
The previous lawyer has given up. New counsel.
Mr. B. Kiriam submits that he's been freshly engaged on behalf of respondents 4 and 6. Stop. He has drawn the attention of the court to an earlier order dated 10/3/2023.
Yes, sir.
Whereby the earlier counsel has submitted that reliance will be placed on the affidavit filed by the district council respondents 1, 2, and 3. Stop. However, he submits, it appears that the district council respondents will not be filing any affidavit. As such, he prays that he be allowed to file an affidavit. However, the response 4 and 6. Stop. In view of the piquant situation, in view of the prayers, prayers 1, 4 to 6 is calling allowed. 5. This is Sangma and 5 is there. You won't be filing. 3 weeks time. 3 weeks time can't be filed.
18.
This matter, Lordship, I'm appearing for the state respondents, Lordship. Mr. Sheikh is appearing for the respondents. It's a VEC matter.
Where's the affidavit?
Lordship, I'll file the affidavit today during the course of the day, Lordship.
Mr. H. Kharmi, senior government advocate, correct?
Additional
senior. Please submit the affidavit find the course of the day. This after 3 weeks for you and your penny.
19.
Lordship, we have taken steps on respondent number 5.
But ED card not received.
I've received, Lordship. I'll be appearing for 5, Lordship.
Mr. B. Panthi.
I've had my power.
Mr. B. Panthi, the council has entered appearance today on behalf of number 5. So the service complete. Officer also indicates that affidavit on behalf 1 to 4 has already been filed.
Yes, Your Lordship.
So how much time?
4 weeks, Lordship.
4 weeks time granted to the respondent number 5 for affidavit.
20. 20.
This is a matter where the writ petitioner and others are seeking pension. We are in a very piquant situation where availability of fund was the main issue.
No, the only thing is that you've got to take instructions whether the representation which you asked them to file has been.
Yes, right from that's why I had suggested earlier to repeal this law because it's operating retrospectively. Normally, it should be prospectively, right from the time it was passed. It was made retrospectively.
Which year? Which year is the act?
2002, Your Lordship.
So since 52, 2002.
They say to all members of. That's how it is. I had suggested that there should be amendment, or at the
But
most.
even then, pensions are continuing, right?
No, Your Lordship. If it is their permanent government servant, yes, but not so far.
One term you get pension.
One term.
One
No,
term,
Even one term
One
is a
term.
one term
they
pension.
start getting pension. They made a law
What's the
for.
amount of pension?
5,000, Your Lordship. Per
That's
month.
all.
No, it's not. That's all, Your Lordship.
It's 5,000, Your Lordship, per month.
5,000 is a small amount.
No budgetary provision also. We are in a very piquant problem.
But Khasit is also financially very well managed.
No, Your Lordship. All this toll gate, everything close.
What to do?
In the previous matter, in the contempt which was filed, there were only 4 or 5 petitioners. So for them, it's approved. Even though they said that there's no funds, but for them it's approved. Only for 5.
So they enjoy the pension.
But the rest they are not getting.
They were before 2022. 2002, you said, no?
2002.
Before they were MDC before 2002.
Some of them, Your Lordship.
We'll look into this matter. Your Lordship.
Looking into it will, I think, help because where's the representation? Have you filed it?
I have not bring on record. I have
Yes,
filed
you
it.
do one thing. Mr. Vijayanta, Special Counsel, submits the representation which has been filed, as it involves as a grant of pension would involve huge financial implications. Is still in the consideration stage. Stop. He prays. There's allowed how much further time?
4 weeks.
4 weeks time to come up with positive instructions.
Maybe we will repeal the law also.
That's not to the.
I'm just
not
saying.
report, yes. MSB Karunang prays for allowed to bring the representation file. We will examine the thing also on record.
That's obliged.
By affidavit.
They can
Before
file
the
an
next
additional
date.
affidavit bringing
Yeah,
that
before
on.
the next date.
21.
Yes. Just after 4 weeks.
May it please, Your Lordship. This matter is pension matter, my lord. The respondents are taking time after time, my lord.
Your Lordship, I think this is the third or fourth time I have the AG has already filed the affidavit. I'll forward it the affidavit of AG and I'll make it. I may be given just 2 weeks time. I'll be
So
filing.
why you are the person who's in charge?
Yes, Your
Why should you communicate the affidavit of the AG? What's the affidavit of the
AG is saying that the department, it's the department.
So
what?
I'll forward it.
Why should you forward to them?
Because I have not received the detailed Paravise comment. So for that reason, I will just
He retired as a head assistant.
Which department?
PWG, my lord. Let it be last chance, my lord.
Bring your chief engineer, yeah.
I may be given.
Take the instructions
I
from
will
the
be
AG.
given last chance.
AG has to act. Chief engineer.
Yes, Your Lordship.
Chief engineer, my lord.
Mr.
I may be given 3 weeks last chance. I'll file it positively.
I don't believe last chance. Mr. H. Abraham pays for further 2 weeks to file affidavit. You file it, otherwise you call him here.
I'll do that, yes, Your Lordship.
Hello, Ibrahim.
I'll oblige, Your Lordship.
22.
Lordship, I'm appearing for private respondent. This matter can be remanded back, my lord, because they're aggrieved by.
Because they suppose there is a direction, a clear direction from this court to file an application for continuation of delay, Lordship. From this court.
As per the last order, the court has directed me to produce the record. I have gone through the application they have filed. In an application, my lord, they have in certain paragraphs they have stated, my lord, that there was a delay and delay may be condoned, but not a specific application for delay of continuation was filed. A mixed application was filed, my lord, where they have also prayed for, my lord, to recall the order. So it is not that a delay of application was totally not there.
As
This
per
is
the,
the
as per
record,
the
my lord.
Limitation Act, they have
They have not filed
mentioned-
as per the Limitation Act. That is the admitted position.
Yes, Lordship. They should have mentioned the number of days with a separate application and the reason for delay. All those things they have admitted in the order, also in the order para 7.
Where condemnations were allowed by this court?
Here, the para 8 of the order of the CEM, Lordship.
Where is that?
That is a relevant page 47 of my writ petition.
Yes, para 7.
Para 7 and 8, Lordship. Para 7, they have admitted that there is no continuation of delay has been filed. In para 8, they said that it was admitted that on the ground that petitioners should not suffer on the due to the power of the advocate. They have mentioned that.
My lord, if I am permitted to read, my lord, para 7, what my learned friend is relying upon. In spite of the Honorable High Court's order direction, in its order dated so and so, the counsel for the applicant has chosen to file this misapplication, appeal, my lord. Is a misappeal, it was registered. Dated so and so only, and no application for continuation of delay was filed, my lord. So here, my lord, in this miscase, my lord, they have mentioned about the continuation of delay, my lord. And this is the application that they have filed, my lord. No separate application was filed.
You set aside this order, Lordship.
No, there is no final order, my lord. It is only delay was condoned, my lord, as per this order.
With a fine.
With a fine, my lord.
With a fine. So what's your prayer here, Mr. Sama?
Here we are here in this repetition we are saying that this order dated 14/12/2020 should be set aside.
14/12/22.
Yes, this is the order of that order passed by the CEM.
So it's on what ground?
Because the direction is very clear, because they themselves are admitted that there is no separate application for continuation of delay is filed, because there is a direction from this honorable court on 9/7/2019.
Woman's client filed the application for continuation.
And this is on earlier occasion also they have come up for that one. Another order was saying that this order was passed, and another CM just allowing to issue the NOCMA certificate. That order also was set aside.
See, the thing is that now see, look at the final thing, because the above in the situation, the case, therefore, this court viewed all these things in mind and considered legally these lapses cannot be condoned. Yet looking at the difficulties and problems we face as appellants due literacy and the poverty, hence the court relieves the applicants who should not suffer due to false instructions of the counsel. Hence the delay is condoned to enable appellants to file a recall petition of the order dated 12/3/2010 of CM. However, cause 3,000 prolonged delay. What is wrong with this?
No, Lordship, because actually if these things are allowed, because the limitation also is very important, because
the limitation act does not apply. This is under the before the CM.
Because you see the order page 35 of the order of the High Court, Lordship. May I just take you, because this is very clearly mentioned. He was only permitted to go before the chief executive member JJTC by way of an application seeking continuation of delay. And seek for record. That was there. Even that order is not complied, Lordship, because they are the reason, the purpose of the Limitation Act is that they cannot just file anything, because without any provision, without any following the due process of law. Otherwise, this will be a precedent, Your Lordship, because there is so much delay, Your Lordship. So much delay, Your Lordship. This is not 50 or 60 days, but this is more than 2-3 years delay. Can this be just entertained? We have to
see the order page 35 also. From that time, the court also said that the chief member in his discretion shall examine the same on its merit and pass orders thereon. It is made clear the impugned orders herein shall not be disturbed. Proceedings are finally concluded. It is further made clear this case will not serve as a precedent in other similar.
Lordship,
that order, the caveat already there from 2019 when this matter was disposed of firstly.
Lordship,
so the caveat will still continue.
From 2019,
now the discretion of the CM, and so in his discretion he says, okay, fine, like the separate condemnation application has not been filed, but in the circumstances, since they're illiterate and they are, they are depressed.
Whether there can be a sympathize against law, because Lordship, then let it matter come out for detailed hearing. I will hear the matter. I will satisfy, because there are so many things.
First and foremost, my learned friend has to apprise this honorable court, my lord, whether in this kind of proceeding, Limitation Act is applicable or not.
It's not applicable.
Second thing, my lord, similar case, my lord, where limitation, he has also come, my lord, where this honorable court, my lord, has passed an order delay was condoned by this honorable court, where we have passed an order that no, there was a delay, we cannot accept. And this honorable court has accepted that.
Delay was only for maximum 50 days. Here is more than 2-3 years, Lordship.
That is not, he will point it out to us, my lord, what is required to be done. This is our discretionary power, my lord.
Let it come up for detailed hearing, then I will try.
Then we'll file our affidavit also, my lord. We'll file our affidavit why you have passed this order. As per this order of this honorable court only we have passed.
This is matter for division hearing after 1 week.
Lordship.
He'll dispose of after 1 week.
Today also
after
it could
hearing
have been
some
disposed of.
Can be disposed of, but let him have a satisfaction of
my lord.
That is apprising his clients.
Much less, Lordship.
Yes.
Hearing, supplementary list, item number 6.
Yes, Mr. Krishi, where were we?
Mr. Lordship. Lordship, straightway I'll come to the page 122. Why we are aggrieved? Because when the execution, they file a petition for before the executing court to execute the judgment and decree passed by the trial court. Then we wanted to file a show cause and we want to say something before the executing court. But in the meantime, why we could not do, this is the order passed by the appellate court. Order dated 12 April 2018. The case is posted for appearance of the appellant. The respondent is present in the court. The appellant failed to appear in the court today. In spite of the fact she knew that the appeal is pending in this court. Also, in spite of the fact the last chance has been given to her to appear in the court. The attitude of the appellant is not appearing before the court in spite of the fact that she has received the notice, knew very well the case, shows that she is no longer interested to pursue this appeal. Therefore, in view of the above observation, this court has got no other alternative but to dismiss the instant appeal. Appeal is hereby dismissed for default and same is hereby disposed of. Sri S.B. Latima has been promoted to the additional judge. Hence, the case records of the execution case number 315, ejectment suit number 1, be endorsed to the file of C. L. W. Fira, presiding officer, Supreme District Council, court for execution. This is the order passed by the court. So what I want to say, Lordship, this appeal was already disposed of. In the appeal which was already disposed of, the same appellate court took up the appeal and passed this order.
What do you mean appeal already been disposed of?
This appeal was disposed of.
This order 12/2018.
This MCA for 17 of 2012 was already disposed of. It was disposed of.
No, but what does it mean that he is supposed to appear, he didn't appear?
No, but this appeal is no longer. It's already disposed of.
Where is the early disposal order?
Yes, sir. Page 26.
(26).
26, Annexure B.
Okay, where's the operative part?
The operative part is that this appeal is disposed of. The case is still disposed of. He said, in my observation, I find whole the instant appeal merit no considerations and the same of which hereby dismiss.
appeal is dismissed, no cost. So this was disposed of on 3rd April 2014.
You are the appellant here.
Appellant here.
You were dismissed of the.
So my appeal was dismissed. Then the District Council Court took up the appeal again, once again.
Why?
I do not know the reasons, how the case was taken up again, and passed an order 12 April 2018. The court,
that only shown just now.
Court has become a functus officio, and again passing an order, taking up the appeal that I am absent, I did not appear before the court, and accordingly, he directed the executing court for executions.
What's this Miss Case 18/16? At page 112.
Substitution.
Oh, that's why it's taken up again. In the Miss Case was filed, disposed of, Miss Civil Appeal. Is that correct?
Disposed of.
For substitution, right? But why was it taken up again on 12th April and this order passed?
That is 12 April again. Why it was taken up? I don't know.
So there's nothing remains. We will disregard this order. Even then, that your appeal stands dismissed by the earlier order. So what release will you get? Nothing.
My lord, 12 April 2018, passed in the MCA 17 of 2012, was in compliance to the order and direction of the Honorable High Court, which is the White Order 13/6.
The High Court order.
Yes.
It's not reflected anywhere.
Why? It must be there. Where's, in which page is it? You've annexed it, Mr. Qureshi?
No.
No.
I don't know. I
The
don't
order
High
goes
Court
against you, you have not annexed it.
High Court order.
The only grounds that the matter was disposed of, taken up again,
Taken
is
up
order
again.
dated 13/6/2017.
12 April 2018.
No. Look at page 121. What is this?
One-to-one order is, after hearing the submission advanced by Learned Counsel, it appears that the matter pertaining to the substitution and
explaining it back for.
Yes, sir.
This is the question about the ex parte and then substitution.
Now, where's the order of the High Court? Where in the petition is it? So, Mr. Qureshi, the High Court order dated
13/6 of 2017 in Civil Revision number 6 of 2016.
Oh, that's different. That is
Yes.
that is one page 122.
Yes.
That is page 121. 13/6/2017. That's already seen. Is regarding authorization also. Therefore, remand the matter back. Let the it appears matter per substitution ex parte judgment. Or ex parte judgment, yes. Should have been agitated before this council court. So we was agitated for whom? Yes, Mr. Qureshi.
Yes.
So what do you have to say about 121? It says that after hearing submissions advanced in counsel with the parties, it appears the matter pertaining to substitution and ex parte judgment should have been agitated first for this council court. Therefore, I demand. That means against that order you came here straight.
No, see, one more order. I just.
You're not prepared the matter at all.
No, see, one more order. One more page 1112.
Where we will get nowhere like this.
My lord, regarding with that, it was already decided in the Annexure B of his petition as well.
Annexure B, that is a MCA.
Regarding the
MCA.
question of ex parte substitution and all.
That was done 2014.
Yes. 2014.
Against that,
Already.
I really don't understand this.
Lordship, there is one more order, Lordship 1112, the page, regarding the substitutions. The miscellaneous application was filed 18 of 2016. Because the number of petition was filed before the district council court, this is creating confusions. This is an application filed by.
No, the substitution that we've seen earlier.
Yes. So in this case, this substitution was allowed by this order. By order dated 7/2/2017.
So, see, you've come against that judgment decree was passed by the trial court against you.
By the trial court against me.
Correct. Then appeal was filed by you.
Appeal is filed?
Appeal was filed, then dismissed first on.
See, the plaintiff died. The plaintiff died on 26/7/2012. Then judgment and decree passed on 28/8/2015. And I do not know whether they have filed any application for substitution. So the decree was passed in favor of the person already died, dead person. So the question is that whether it is a nullity.
Forget about that. What do you do? You file an appeal against this. You file an appeal against this judgment decree. Correct? You file an appeal.
File appeal.
You file an appeal. Correct?
Yes. Judgment decree we have not filed appeal. We file an appeal against the ex parte order only.
Ex parte order of what?
Before proceeding for passing a judgment, the court passed an ex parte order.
So you never challenged the judgment that came afterwards?
No, I have not challenged.
You didn't file application order 9/12/13?
We have not filed. We have not filed. I have not filed.
Order 9/12/13?
Yes, my lord. He filed, and then it was dismissed
Mr.
again.
Kurishi, please. I'll post it tomorrow. I'm posting it tomorrow. You be ready with the facts. We can't carry on like this.
Because
you're a seasoned counsel. This is a matter tomorrow for the hearing.
The confusion is that
no confusion.
They themselves have filed an application of substitution in 2017, and again they filed one review applications.
You just come with the chronological list of what happened and submitted to the court by tomorrow.
And the judgment decree was reproduced again in 2018.
No point arguing if you're not clear about your own facts also. Yes. Connect matter. Just tomorrow. We'll dispose of tomorrow.
7.
So count 18 has been hanging. Yes.
Please, Your Lordship. Lordship, I have a misapplication for the release of the salary, my lord.
Already filed.
Yes. So the copy.
Of course, I have not received the copy. I'll
The
try to
body,
find
sir,
out.
my lord.
This case number 29/2023, WPC 46. This misapplication is for this action been filed praying for directions to the respondents to this petition salary pending from the month of January 2023. Stop. Mr. K.B. Baraji accept notice. Yes, the matter after 2 weeks.
Main list 36.
Where is the PG someone? Call him. how it will resolve your problem?
Also, I think Lordship will recall, at one point of time, Lordship had indicated that order will be passed. State were directed that to obtain instructions and take steps on their own. Subsequently, the managing committee, they produced the service record of the, and it is in my favor. Lordship, kindly come to annex at page 6.
Of the affidavit?
No, Lordship, the service record.
Where's the service record? Where is service record, Mr. Sangma? Service records yet produced last time?
If I may, Lordship. Page 6. This is the subsequent to the notification of the state respondent to terminate my service and to conduct fresh selection. An emergent meeting of the managing committee was held, and the same was communicated to the state respondent, wherein it is clearly stated also that my case of regularization was placed before the state respondent way back in 1997, and throughout they had been remaining silent.
Where's the state? You're aware of this? You're aware of this, sir?
Thereafter, Your Lordship, she was appointed as substitute teacher initially, and thereafter she was appointed against the leave vacancy.
See, what do you have to say of the solution of the school where he said that, fine, she is appointed, but then they want to regularize her service with retrospective effect?
I think, Lordship, as per the record, Your Lordship, if we go from the page 23 of the report also, she has only make a prayer only for appointment of assistant teacher. There is nothing mentioned for regularization. She has even never approached. The record speaks, my lord. And also, government also have given that she is not qualified. As per the NCT norms, Your Lordship.
She didn't want to apply. She was appointed in. When she started working as the leave vacancy?
Lordship, 1997.
Lordship, that page 23. To the secretary appointment.
Lordship, I was appointed in 1986 as an assistant teacher. Thereafter, as in the LP section in 1997. And my case was placed before the government in 1997 itself for regularization. Throughout they had been slumbering. Suddenly they wakes up in 2018 and comes out with this kind of notification also.
No, that time 97, Mr. Gurung, it was not for appointments, for appointments. They sought approval from the reports that to appoint a substitute teacher in place of in a leave vacancy. That's all.
Not for regularization.
It is also reflected that at that point of time, I was within the age limit and also qualified.
A bit difficult.
Also,
But the fact remains that she's a senior most ad hoc teacher from that time.
Yes. So from 2018 onwards, I'm not getting my salary, not to speak of the increments.
You're still teaching now?
Lordship, my presence is not recorded, Lordship. That is the sorry state.
But are you paid?
No, Lordship.
You've been working free for how many years?
Since the passing of this order in March 2018. Kindly, Lordship, this has been lingering for a long time. Pray that it may be disposed today.
Your Lordship, regarding whether she's still teaching or not, Your Lordship, if we may be allowed to verify.
I'm not into that. I'm not into that, Lordship.
Have you filed? Did you file this from a affidavit? Have you filed these documents?
This document I have not filed.
You file them, we'll dispose next date. Because appointment for ad hoc for 86, we'll work out something.
That's
Even then. Can
Lordship, I respectfully submit, Lordship, that I'm not claiming for my regularization from 1986, but 97, when I was initially appointed from being the senior most to LP.
Your Lordship, when at that time she was serving against a leave vacancy, Your Lordship, not a.
It is on record.
Your Lordship, at that time the teacher who was in that post also, who was on leave, was still there, Your Lordship. So that cannot be done.
no, let him file. You file his records. The records produced by you have respondent number.
Respondent number 5.
105. So maybe file be brought in record by way of affidavit for effective orders to be passed. When can you file it? Within 1 week.
No, 2 weeks, maybe 3 weeks, because I have
File
so
it,
many
yes,
other
because we
things
have to
also.
take judicial notice of these. It's not, has
Yes,
not come
yes.
anyways.
That's it, yes.
Yes, wrong, no? So the relevant documents from the records produced by one file may be brought, brought on record by way of affidavit. Yes. Stop Mr. Someone else counts 105 granted 2 weeks time for the same thereafter and so on. So yes.
Yes, Your Lordship.
37.
Lordship, I file my that affidavit bring on record the order of my acquittal, Lordship. I have been honorably acquitted by the court below, Lordship.
May please, Lordship. Lordship, I've just received this judgment this morning, Lordship. Lordship, I place up a week's time.
Yes, after it's been filed by the petitioner, we will record the factum of judgment of acquittal dated 10/3/2023 of the petitioner. Stop, Mr. H. Karonlang pre-responds allowed 1 week's time to study the same.
My lord, if that observation is come from the court, that pendency of the writ petition shall not be the bar, so that I can put up
1
my
week. Yes.
Much obliged.
39.
See, this matter was already heard last occasion.
I don't remember anything.
Regarding the person who was I'll refresh again. I'll just go one by one.
Oh, poultry attendant.
Poultry attendant, yes. Now he's promoted only after his retirement only. Then they said he is not entitled. He has reverted back to his post, original post. But he already served as a driver for 15 years.
On what ground?
The rules do not permit, my lord.
No, but the government, as per the FRSR, the government even can relax the rules. But his service could have been brought to end before his retirement, before superannuations, not before, after that.
How long he served in the other post?
15 years, till his retirement, as per the order. He was page 14, 12 July 2018. Series Elias Marvin Poultry Attendants is allowed temporarily to hold the post of driver under the office of the Assistant Dairy Development Officers, Joy in SK Lopez so. Other allowances admissible under the rules with effect from the date of joining.
Where's the impugn order?
Impugn order is
page 21.
21. Page 21. He said, with reference to your letter number on the subject cited above, I am to inform that as per the finding of the finance account officer, on checking the record, it was found that C. Elias Marvin, retired senior grade driver, was initially appointed by District Selection Committee, East Khasi Hill, District Shillong, as poultry attendant. Later, he was allowed to officiate temporarily in the post of driver with effect from 12/7/1980 till his retirement date. As there is no provision in the service rule to promote the office peon to the post of driver, moreover, it appears that he was allowed to
promotion for the post of senior grade driver. Hence, his service has to be reverted back to the original post of the poultry attendant as per the instruction of finance and account officer. Since the officiating appointment to the post of driver is highly irregular, it might attract further complications. That's there said.
So when you were promoted to this post as in
senior grade
you
post.
were paid the scale of senior driver, correct?
Senior driver, yes.
So you enjoyed it for that enough. Now that was officiating. It takes officiating promotion then. Official appointment.
No, as per
against
this,
that promotion, if the rules
because
don't allow it.
they allowed me to go undergo for training also. After I pass my training.
Not the question is been deprived. So substantive pay will be a poultry attendant,
Yes.
and your pension will be fixed accordingly.
Yes,
unless you can show some authority.
The authority, Lordship,
show some authority that says otherwise. That okay, the rules not permit. You've been wrongly, so that error was rejected.
Because it is
At
not
least
my
they're
fault.
not asking for recovery of your pay.
As per the affidavit filed by them, it is not my fault. They
It's
said
not your fault.
they have admitted their fault.
It's not your fault, yes. But whether due to their fault, would you be allowed to draw pension now at the higher at your higher last paid run? Show some authority.
No
to show
authority.
that you were promoted, wrongly promoted, okay, and then like,
Wrongly promoted. I am not wrongly promoted. They have promoted me after allowing
a poultry attendant. Okay, from a poultry attendant, there's no promotional avenue to driver, let alone senior grade driver. Now you are poultry attendant, then they promoted you.
No, they have not
against the
promoted me.
rules.
They have allowed me to temporarily hold the post of driver in 1985.
Officiating.
Officiating.
You paid.
So from the
you officiating against
from the officiating post, I was never reverted back to my post. They allowed me to continue.
You're officiating as a regular vacancy, so you paid that scale, correct?
Yes.
So you enjoyed that scale from 85 to retired when 2020.
2020.
September 2019.
So
finance department, Lordship.
Exactly. Now can you show some authority that says that your official appointment can be converted into substantive appointment and your last paid drawn will be calculated from that time for the
No, it is the
purposes
government
of fixation of your
if the government
pension.
take a decision under the FR, they can relax the
What
rules.
does FR say, show? You got FR with you?
No, FR I didn't bring, but
Mr. Gurji, what's wrong with you? You're a senior counsel and
because government has never said
I'm not talking
in the entire
but
affidavit.
at least prepare the matter properly.
As per my instructions, my lord, it cannot be done. In fact, poultry poultry attendant in earlier occasions, my lord, in the without the, my lord, when the 2017 rules came, prior to that, my lord, poultry attendant, there was a chance that, my lord, there could have been a less level of promotion till the post of
Me this post, they themselves has promoted me. They allowed me to hold the post as a officiating driver. Therefore, I will go to the promotions.
Yes. Yes, Mr. Qureshi.
Yes. So this is my case, Lordship. The entire affidavit is gone through, Lordship.
In fact, my lord, there was another similar matter in the department, my lord. Of course, that person never approached. And subsequently, my lord, he was reverted. All his pension, everything was settled in that manner, my lord.
Yes, you have the authorities.
Lordship, authorities is very difficult to find the affidavit on this. But FR3 it says the Meghalaya Fundamental Rules and Subsidy Rules 84. The government may relax the provisions of the rules and orders so made by its such a manner as may appear to be just and equitable. Provided where any such rules or order are applicable to the case of any person, the case shall not be dealt with any manners less favorable to him. But the law is settled. One of the judgment I found, but it's not very clear judgment. The before the
If
superannuation.
the law settled and the judge is not clear, what do you mean by that?
But it's
So the law, can it be settled or it be unsettled?
No, because that is in different contexts, in different facts and circumstances. He is a compulsory retirement. He is a grip. The post which who is holding, he will give you entitling all the benefits of that
Maybe
post.
take down. The petitioner before this court was appointed in 11/11/1981 as a poultry attendant in the Department of Animal Husbandry and Veterinary, Government of Meghalaya. Stop. Thereafter, on 12/7/1985, the petitioner was allowed to hold the post of driver temporarily under the office of the Assistant Dairy Development Officer Jawai, and was even promoted to the post of senior grade driver on 17 September 2015. Stop. On attaining superannuation, the petitioner was informed by the impugned letter dated 1st September 2020, issued by the respondent number 3, that he was reverted back to the post, to his original post of poultry attendant, in view of the fact that his officiating appointment to the post of driver was irregular, inasmuch as there is no provision in the rules for promotion to the post of driver. Far less, petitioner being aggrieved thereby is before this court seeking directions that his pay settlement be fixed in the post he last served, that is of senior grade driver, for fixation of his pensionary benefits, for fixation of his, you have to set in a prayer. For approval of his last pay, that his service benefits, including pension, be fixed as per the pay scale of a driver and not as the poultry attendant. Stop. Next paragraph. Mr. M.F. Qureshi, learned counsel for the petitioner, submits that the petitioner has been serving as, after his initial officiating appointment, since 1985 in the post of driver, and after the retirement, the reversion is highly unjust, and arbitrary stop. He further submits that reversion, if any, should have been done at the time when he was still in service and not after he has retired. Legal counsels also place reliance on FR 3. I don't think up anyway since you made submission. Show your book.
Lucy, I didn't bring the book.
You didn't bring the. Where are you reading?
Just extract I took out from the net only.
This book, the way it's been arranged is very confusing. But it jumps.
I just it's not a proper way.
Thoma? Three of the Meghalaya Fundamental Rules 1984 that the provisions of rules or orders so made be relaxed, be relaxed so as to appear the one that M provides us. Boleh makan sedang sih, boleh.
Also express reliance on the rules, necessary rules 1984, that the prohibition on
The FR3 allows state government to relax the provisions of rules or orders so made by it in such a manner as may appear to it to be just and equitable. Next paragraph. What are your submissions, Mr. Kimi Barasaji? Mr. Kimi Barasaji dated counsel for the GA.
Firstly, my lord.
Where's the rules?
My lord, of course. Rules we do not have it, my lord. Close, my lord, with the affidavit. This is office memorandum dated 22nd May 2000, my lord.
Where are the rules? Mr. Gibran, in reply, has
this is, my lord, this is only with regard to this OM is only at the
next higher post. What is this?
My lord, of course, that was on instruction. That was earlier.
Where are the rules?
The rules I don't have it today, my lord.
my lord allows, then I can bring it.
Rules is there. Rules is there. Meghalaya Secretariat driver rules.
Not secretariat driver rules. Veterinary don't have their own rules.
Yes.
We're not talking about driver rules, talking about poultry attendant and where like, because the court is just interested if to examine the scale of pay with drivers getting poultry, then next higher post poultry attendant if the scale is the same as per the driver. Then we can give you some relief. Otherwise, just after 1 week to enable you produce the rule.
40.
Waste of time. Bu tu that type of bu.
This matter will have to be reheard again because the settlement talks have failed. So,
what settlement talk were they?
May it please, Your Lordship. Your Lordship, Mr. Shulai is arguing in this matter and he's on legs at the moment, Your Lordship.
When you wanted? Mr. Nobody looked prepared today also.
no, I can, my lord. It's a lengthy matter. I can.
List the matter after 2 weeks.
Obliged,
At the
Your
request of the GA.
Your Lordship, 40 and 41 are connected matters.
What's the matter about 40, 41? Promotion?
No, my lord, they've been under suspension, indefinite suspension since 2014.
Oh.
Question of law, my lord.
Obliged, Your Lordship.
Supplementary 1. Item number 1.
My senior will be moving the matter.
He was here just now. Where is he?
Please, Your Lordship.
Which justice will appear on the other side?
My lord, I'm appearing for the number 1, my lord. Respondent number 1. I'm instructed to appear, my lord.
Possessing the plaintiff on the suit premises without following the procedure of law. That was my limited prayer. Now, what happens, my lords, is the trial court, my lords, rejects my prayer for a grant of any ad interim injunction. I prefer an appeal, my lords. At page 69, there was an order of status quo.
Page
69 minutes. This is passed by the first appellate court.
Okay.
Meantime, party shall maintain status quo with the next returnable date. And thereafter, my lords, I'll take your lordships directly to page 74.
Yes. Yes.
Defendant before the learned court of District Judge Shillong. On careful perusal of the order dated 4/12/2020 passed by the Honorable District Judge East Khasi District in FAO number 2H of 2020, it is found at para 8 of the said order, which is reflect as under. That since the respondent has filed an application giving undertaking that the appellant will not be evicted, and if at all the appellant is to be evicted, the respondent shall follow the due procedure of law. The undertaking advanced by the respondents on being examined juxtapose the prayer made by the appellant and the plaint for decree. This court finds that the apprehension of the petitioner of being forcefully dispossessed does not survive for consideration, and further the respondent has also undertaken that the appellant shall be evicted only by following the due procedure of law. Prayer in the title suit of the appellant does not survive for consideration. As of the parties are not an issue, in other words, the issues raised by the appellant in the title suit has become infructuous. Consequently, there is no cause of action in the title suit. In view of the observation made by the Honorable District Judge in order dated 4/12/2020 passed in FAO number so-and-so, and considering that the defendant has already given an undertaking before the Honorable District Judge Shillong in FAO number so-and-so, that the plaintiff appellant will not be forcefully evicted, and if at all the plaintiff appellant is to be evicted, the defendant respondent shall follow the due process of law. This court is of the opinion there exists no more issues to be adjudicated upon the suit. The instant case is hereby disposed of. So, my lords, thereafter what happens is...
So your suit is disposed of?
My lords. In essence, my lords, there is a decree in my favor on an undertaking given by them that they will not evict me. At page 75, my lords, they then file ejectment suit number 9 of 2020. Your lordships may kindly see at page 75.
Yeah.
My lords, this is a suit for ejectment of the defendant from the suit premises at Police Bazaar, Shillong. Your lordship will see plaintiff is the respondent number 1, my lords, and the defendant is respondent number 2. The prayer, my lords, will find at page 77.
Ejectment on what grounds?
Bona fide requirement, my lords.
Page.
That the averments made in para 1 of the plaint is not known to the answering defendant as the owner.
Page, statement, the page?
Page 80, my lords, 80.
80. Okay.
Your lordships have it, my lords.
Yes.
Paragraph 7, if your lordships kindly see.
Yes. The averments made, yes.
Yeah, the averments made in paragraph 1 of the plaint is not known to the answering defendant as the ownership of the shop never came to the answering defendant. It is submitted that neither the answering defendant lifetime had been the owner of the suit premises and were only paid but also may likely change the character of the pending suit due to additional cause of action as well as relief, and therefore it requires it is required and appropriate that the applicant deemed. My lords, and a prayer your lordships will find at page 84, it says, it is therefore humbly prayed that your honor may be pleased to admit this application and allow the applicant plaintiff to withdraw TS number so-and-so, liberty to file a fresh suit accordingly.
Okay.
Now, this comes to be dismissed, my lords, by page 85. This is order dated 14/9/2021.
Yes.
At page 86, if your lordship sees, my lords, the finding of the court is, it is observed that non-joinder of parties is not a formal defect but a material defect. In view of the discussion above, the application filed by the plaintiff to withdraw the suit with liberty to file afresh is hereby rejected.
Okay.
So once this happens, my lords, at page 87, they file a fresh suit against me for eviction.
But they didn't impeach you in the old suit?
My lord.
Okay.
At page 87, my lords, they file ejectment suit number 1 of 2022, and your lordships will see the prayer. At page
87?
I'm sorry, my lords. Page 87, my lords.
87 is here's the middle of it's para 16, 17, 18.
This is 87. If your lordships have ejectment suit number 1 of 2022, my lords.
Yes. Internal page number? Because I think the page, something wrong with pagination. Internal page number?
Well, let's your lordships will come directly to the internal page at internal page, my lords.
Plain.
My apologies.
Yes. At least get the page in order, otherwise it's very confusing.
It is very difficult, my lords.
Yes.
My lords, they say plaintiff prays before this honorable court for a decree. The plaintiff from the defendant.
Yes.
Direct the defendant to pay area rent, permanent injunction, etc., etc., my lords.
Yes.
Now, interestingly, my lords, at page 220 above ejectment suit, the second party voluntarily approached the first party to settle the pending case amicably and expressed a willingness on the basis of verbal monthly rental agreement, and the second party took over the second suit premises after the sudden demise of her deceased husband, Neil Ratan Dey, on 7/2/2020, and she continued to occupy the same till date and contested the pending suit. Thus, the second party is in appreciation, it should be, my lords, of the facts and desirable to resolve the dispute once and for all. She has surrendered and handed over the possession of the suit premises today by handing over the key to the first party after collecting all her belongings, as she wants to lead a peaceful life. First party in reciprocation has also hereby willingly agreed to withdraw the above pending suit from the Honorable Court at the earliest to show that no case is pending against her.
Yes.
If your lordships have page 251, my lords, may I just read the prayer?
You're asking for the restoration of possession.
My lords.
My possession's already gone.
Illegally, my lords, your lordships will kindly see how this entire thing has been affected. Because on his own bearing, my lords, the plaintiff says that I am to be evicted from the suit premises. My lords, that is on the background of, or rather in the teeth of the undertaking given by them before a competent court of law.
Yes.
In the premises of aforesaid, it is most humbly prayed your honor may be pleased to pass an order of interim mandatory injunction restoring the possession of the suit room illegally grabbed in the garb of entering into an agreement with the opposite party number 2, and further be pleased to pass necessary orders
of prohibitory injunction restraining the opposite parties working for and on behalf of them or the instance from transferring the suit premises, from creating any third party interest, or from doing any such act that may adversely affect the petitioner, and from doing anything that may adversely affect the petitioner, my lords. Now, the learned trial court, my lords, at page 252, well, it's last paragraph. I'll just take your lordship straight to the last paragraph. At page 252, minutes. On perusal of the plain petition and other materials on record, it is observed that the suit premises was already in possession of the opposite party number 1, and it appears that there is no urgency to hear the matter and pass orders without giving the opposite party sufficient time to file the show cause and conduct hearing. In view of the above, this court deems it fit and proper to give the opposite party sufficient time to file the show cause and take up the hearing. Opposite parties to file the show cause on the next date fixed, failing which necessary order shall be rendered, fixed 27/1/2023 for show cause and hearing. Now, in the meantime, my lords, taking advantage of the vacations, my lords, they start changing the nature and character of the shop room. So, my lords, I go and file an appeal before the first appellate court. Now, the first appellate court, my lords, instructions, so kindly pass some ad interim orders. And, my lords, the orders of the learned first appellate court are at page 267. And I'll skip the, my lords, the factual part of it. Your lordships may kindly come to page 276. That is the operative portion of the order. 276, my lords.
Yes.
Paragraph 9, if your lordships can have it. Learned counsel for the OP number 1 submitted before the show cause has already been filed in case number 46H of 2022 before the Court of Assistant District Judge Shillong. The learned counsel submits that there is no merit in the application as the petitioner appellant was never in possession of the suit premises. Before the same court, my lords, there is an undertaking given that I will not be evicted without due process of law. There is an eviction suit filed against me, and now they say, my lords, I was never in possession of the suit premises. Your lordships have it at para 9, my lords.
Yes.
The learned counsel further submits that the petitioner appellant has been a defaulter in payment of rent and therefore is not entitled to any protection. From a bare perusal of the order dated 9/12/2022, it would be clear that the learned Court of Assistant District Judge has not heard the parties on an application under Order 39, Rule 1 and 2 CPC, and the order merely reflects the order of the court, reject of the petitioner for an urgent hearing of the matter on the following week, that is 9/12/2022, without giving the opposite party sufficient time to file the show cause and conduct hearing. It appears from the order of the parties having not been heard on the application for grant of injunction, since a similar application under 39(1) and 2 in respect of the suit property is still pending before the learned Court of Assistant District Judge, and the parties are yet to be heard, this court is not inclined to pass any order on the application under 39(1) and 2 CPC. Moreover, as stated by the learned counsel for the opposite party, that show cause has already been filed. Therefore, the learned Assistant District Judge is hereby directed to hear the parties and shall endeavour to dispose of Miss Case number so-and-so within 2 months from the date of this order. So, my lords, this neither leaves me here nor leaves me anywhere. And, my lords, taking advantage of this, the photographs are there before your lordships, my lords, what is going on, even while the suit is pending. Not only my suit, my lords, a so-called eviction suit filed by them.
Yes.
This was the original signboard your lordships will kindly see at page 279, my lords.
Now,
TK Panti.
What's this Hooch store? It's become a Hooch store now.
I'm sorry, my lords.
Page 2822.
282. Your lordships, just bear with me for a second.
They've changed to Hooch store.
Yes, my lords. So from a watch store, now it's become a Hooch store, my lords.
Yes.
My limited grievance before your lordships will kindly see, my lords, the manner in which this entire thing has been done.
Unfortunate, but you are unfortunate is the circumstances.
My only prayer before your lordships is my injunction application is pending to be heard by the learned trial court. First appellate court, my lords, by simply making an observation that you hear it within 2 months and make an endeavour to hear the matter.
Now, what orders injunction can be passed?
My lords,
Apart
at least
from like no further reconstruction or no
nothing further. My only prayer has all along been, my lords, let status quo be maintained as on today. Please don't create any third party rights, because what would essentially happen, my lords, now some third party will come and say that I
have to complete Hooch store now.
Hooch store will come in, my lords. And your lordships, why I am before your lordships under 227 is this the manner in which, my lords, after you give an undertaking before a court, and your lordship will see the attending facts and circumstances, can this be done? and the trial courts and the learned first appellate court appears to be a mute spectator to this kind of illegality being patently perpetuated as against the petitioner.
Yes, you are appealing for?
Number one, madam. Respondent number one.
Number one is the owner of the full property.
The landlord, madam. The landlord. Now what happened?
No, by
my lord, he is absolutely a stranger.
Yes. You see, I will not say anything, but we had, like, when I was practicing in Guwahati, such cases had arisen where, a suit's filed against, suppose property belongs to Mr. Paul, suit's filed against Mr. Panthi, decrease is obtained, poor fellow sitting in his home, gets the bailiffs come and throw him out from there.
Here we didn't even have to wait for the decree. Mr. Panthi goes and surrenders the possession.
Mr. Panthi goes and surrenders the
possession.
42.
42, sir. This is that matter concerning large interpretation of section 56 of the Electricity Act.
Yes, Mr. Sai.
My learned friend has filed a very detailed affidavit raising some preliminary objections.
What pre-objections?
Lordship, objections are as to the maintainability of a writ petition in such a case, because essentially this is a case pertaining to dues of electricity and consequential termination and disconnection of electricity due to non-payment of those dues. So now, in fact, the division bench of this honorable court has also clarified in a judgment that payment of the statutory dues is in fact obligatory upon all the beneficiaries of
It is not a question of payment, non-payment, that part has gone because they've disconnected. Now the larger issue is what is the scope and ambit of section 56 of the Electricity Act? The only thing is that there was a second writ petition filed before this honorable court, and your lordships had been pleased to dispose it of by judgment and order dated 29/12/2022, where my lords, I was required to make a representation to them. Now that has been made, and apparently I am instructed that was rejected by the respondent corporation. So that if your lordship permit me, I will bring it by way of a small affidavit, so the entire conspectus of the matter can be
will be whether it's the time when you can.
2 years,
Yeah, 2 years is the outer limit where you can.
Here, because the facts are very peculiar. We come before this honorable court, your lordships the matters referred to the National Lok Adalat. There is a settlement before the National Lok Adalat. Now, under that settlement, there are two parts to it, where I am required to make a payment under first installment, second installment, which admittedly I make. B of that particular settlement, says that both the parties are to sit together and work out a settlement formula for settlement. Series of meetings happened, it is, as a matter of fact, the last meeting just prior to COVID shows that the respondent corporation says that we will call for another meeting to discuss this matter. In the meantime, they issue a termination order, a disconnection notice. So therefore, the question comes, that of admitted dues which are prior to 2 years, whether the powers are vested under section 56 can be invoked by the respondent corporation. In the meantime, after orders were passed by your lordships, vacating the interim order of stay, they have disconnected. Your lordships, we had come back before your lordships had directed us to file a representation. We've done that. They have rejected that.
Have you
payments made by us to the respondent corporation during
also the
currency of this.
Of payments that have since been made to the corporation. Appraise allowed this after 2 weeks. Will you 2 weeks?
No, yeah. Because it is also my case, that after this writ petition was filed, I have made additional payment.
And 56(1) carves out some exceptions, I think.
There is an exception. And it's covered by that judgment. Your lordships we placed Honorable Justice Indumala Uttara's judgment and Justice Lalit. They've settled this issue.
Yes.
Obliged.
43.
No.
Please, your lordship.
Yes,
this matter was actually for settlement, your lordship. But
Settled.
after certain proposals from me, it doesn't seem like there'll be any settlement, your lordship.
Succession, the file is so big.
Yes, lordship.
Who's okay? Your petitioner is the.
Appellant is the first wife, your lordship, and the respondent here is the second wife. And your lordship, I've been denied the entire succession, and entire succession has been granted to the second wife, your lordship, respondent here.
Or is this a regular first appeal under Succession Act? You ready? So when will we have it? Parties submit that the settlement for talks have since failed, and the appeal matter be taken up for hearing when?
After 2 weeks,
After 2 weeks, yes. It's a matter of 2 weeks.
Oblige, Lord.
44.
Amzad Khan, the actor.
This is the matter where I'm aggrieved by my order of termination, my lord, for unauthorized absence for about 3 months. My case, my lord, is that the absence was not willful on my part because I was hospitalized. Policeman, my lord. Because I was undergoing treatment, I was in the hospital, and upon joining my duty, my lord, they have issued me the show cause. Unfortunately, my lord.
That means when you are on leave, you went unauthorized leave, that means.
Yes, the case is that I was on unauthorized leave. I did not inform them that where I have gone.
Okay.
But my case is, my lord, that right from what has happened here, my lord.
Or some illegalities in the process.
Lordship, illegalities in the process, my lord. My first ground is that the notices which were issued prior to the order of punishment, my lord, were issued to my address in the village, with my native village in Bihar, lordship. And I was not aware of any of those notices to come and give my explanation. So, and because I was admitted here in Civil Hospital Shillong, my lord, and my case that they knew it because I had this issue of illness, my lord, since prior to this particular period, lordship. Be that as it may, when I joined my service, my lord, in the month of March, I was given the show cause, which was dated much earlier, saying that you should give your reply. Unfortunately, I could not give my reply at that point of time. Thereafter, the DP was held and I was terminated from service, lordship. 3 grounds I have, lordship. First is that this is termination of service, lordship, is a very drastic punishment. It is probably the highest punishment that they could have given on me for the allegation that I was absent from duty for about 3 months, lordship. So that may not be, my lord, proportionate. They could have gone for a censure or a withholding of pay or anything like that, my lord.
Yes.
So first ground is, my lord, proportionate. The punishment itself is not proportionate to the allegation, and that whether it is proportionate or not, my lord, has to be seen on a case-to-case basis. There cannot be any straitjacket formula, lordship. And the second ground, my lord, is that although I have not filed the show cause at the end of the day, initial chances where I could have explained my situation also was I was not aware, I was deprived because the notices were given to my address which I never received, my lord, whereas I was lodged in the hospital here. And my third ground is that, my lord, it has been held in various judgments of the Honorable Apex Court that in a case of my lord, in a case of unauthorized absence, it has to be willful, my lord. There has to be a specific finding and it has to be proved by the employer that I have been willfully absent and it was not for a reason that is beyond my control, lordship. So that is my case, my lord. If I may take your lordships through the petition. Lordship may have page 50 straight away, lordship. Page 50, annexure 11.
Now your DP was for which period?
Lordship, DP was for the...
For authorized absence for which months?
Lordship, from 14th of December 2019.
14th?
December, 14/12/2019.
Yes.
To 18th of March.
18th of March?
2020, lordship.
Okay. So, okay.
Yes, my lord. So, lordship, I come to straight first to page 50, Lordship, Annexure 11.
Yes. Page 50.
50, Lordship, of my writ petition. In my writ petition, these are all the documents which I have received, Lordship. Annexure 11, Lordship, page 50.
No, one thing, Mr. Deb, you know one thing, that this court's not sitting in appeal. Okay?
I understand, Lordship. I understand.
It's not sitting in appeal on the findings or on the. Only thing is that if you have to show there is some, like patent illegality or irregularity in the proceedings.
Yes, Lordship.
And the only thing will on the bedrock of whether you're going to possibly be heard or not.
Lordship.
And regarding your absence, you see, you're a discipline force. So the court will not have that much.
11, Lordship, page 50.
Yes.
This was the notice, my lord, which I have received, the first notice which I have received. Lord, it is not dated, but it has been issued in authority. And whereas several notices were served to you, but you failed to report or resume your duties, it is prior to this notice, Lordship, so that I could explain that I am lodged in the admitted in the hospital, Lordship. Since I have been appointed as the inquiry officer in the above DP, therefore you are directed to appear before me on so and so date, Lordship.
So how do you come to know about this notice, page 50? How do you come to know about it?
No, this was given to me after I have joined, sir. After I have rejoined, my lord. They have given me
They give you notice after you rejoined.
Yes, along with, my lord.
So this was sent to your home address in Bihar.
This was, yes, my lord.
Was there any way that they knew where you were, your whereabouts, that they could not
Because
send
I
notice?
was at the hospital from 2018, my lord. Not that I was hospitalized.
No, was it with the knowledge?
It must
about
have
your
been, my lord,
whereabouts?
because I am otherwise resident of Shillong.
You can't assume that they should know. Was any information given any point of time that I, Amjad Khan, I'm hospitalized?
No, it was known to them. Why I say
No,
so,
but
my
when
lord.
you proceeded, also, you were sick, you say. Okay, that's consideration is there. Did they know about your whereabouts?
Why I say so, my lord, is that initially I was appointed. I was admitted in the hospital way back in July 2018. Thereafter, I was discharged. I came into joining service. They knew that I was having this issue, lordship. Thereafter, I again was admitted in the hospital, and finally, this order, they have terminated me, my lord. So when I have rejoined my service, they have given Annexure 12, my lord.
Okay.
If I may read, my lord, this would help. The drawn against the delinquent ULNK Amjad Khan 1st MLP Battalion Moyong was drawn wide so and so number dated 8th of May 2020 as the delinquent failed to amend his misdemeanor and continued to remain absent with effect from. So they knew, my lord. Why they are saying that I failed to amend my misdemeanor? Because earlier also this was the same situation where I was hospitalized. They initiated some proceedings and they gave me certain punishment.
Continue. No, talking about that period only.
Lordship. So
from
here,
December till
yes.
18 March, like you said, only 18
yes.
March.
Continued to remain absent. Why I am saying, my lord.
Yes.
Continued to remain absent from.
That's
yes.
That's the period, relevant period of which it dropped DP.
Lordship.
Right. Okay.
Without obtaining approval from the competent authority, it is imperative to accentuate that prior to initiation of DP, this was the, my lord, previous DP which I was talking about, where my pay was withheld, my lord. Few DPs are there. So I will skip that part, my lord. And
DPs are there with me.
Long times was also issued on 18 January, directing the delinquent to resume duties, but the endeavor was futile as the delinquent failed to resume his duties, thereby resulting in drawing of this instant DP, lordship. Keeping in mind the principles of natural justice, a show cause was issued, wide letter number so and so, dated 4th of March 2020, consisting the charges framed against the delinquent and the statement of allegation was served to the delinquent with the direction to submit a reply within 7 days. However, the same could not be served as the whereabouts of the delinquent could not be ascertained. So the show cause, my lord, was not served to me. The show cause dated 4th of March was served to the delinquent on 18th of March, which was the date the delinquent resumed his duty after his willful absence from duty. Despite receiving the show cause and knowing fully well he has to submit reply within 7 days, he did not submit any written explanation. So that, my lord, I have said that admittedly I have not submitted, my lord, the reply. The disciplinary authority, on being intimated regarding the lack of response on part of the delinquent was compelled to pass an order that the DP shall be initiated, hence this DP. So thereafter, my lord, the DP is there. On the next page, my lord, relevant portion would again start from the third paragraph, lordship. The prosecution witness at the time of deposing stated that the delinquent was found absent with effect from duty from 14 December when he was detailed for night law and order duty at Shillong. It is also stated that the delinquent resumed his duties on 18th March after being willfully absent for a period of 96 days. The delinquent himself also admitted that he remained absent from duty as he was suffering from physical ailment.
Psychiatric ailment?
Psychiatric ailment, lordship, yes. The EO, inquiry officer, after recording the required statements and after adducing the merits and demerits of the evidence placed before him, submitted his inquiry report and findings on the 25th of May 2020. On perusal of the report, it is observed that prior to submission of the findings, the EO had accorded ample opportunities to the delinquent to present his case. The statements of a disciplined force. Moreover, on perusing the records, it can also be seen that the delinquent is habitual absentee who has been, so they are talking about the previous ones. Therefore, based upon these enunciated facts, I do hereby pass this order without prejudice, impartiality and biasness, keeping in mind the principles of natural justice, that the delinquent is hereby awarded the punishment of removal for service. And my lord, I was also informed that I have the provision of appeal. So thereafter, lordship, I have preferred an appeal before the Inspector General of Police at page 55, lordship, wherein again, my lord, I have narrated the entire facts, and along with the, my lord, medical certificates and other documents, with a prayer to set aside the order of removal from service, lordship. However, my lord, unfortunately the appeal was not disposed of, so we had to approach this court. That has been recorded in the
Which you never bothered to inform the competent authority.
No, it was known to them, lordship.
Known to them means what?
Because
what one sepoy does in the corner of the jungle is known to the DG.
No, why I'm saying it was known to them is because earlier also they initiated DP. That point of time also I took the same plea that,
and still were lenient enough not to remove him service at the point of time.
That was for 1 week. They withheld my pay, lordship.
They were good enough not. You see, you have to look at the antecedents also. You're a disciplined force.
Only on one occasion, my lord. And this entire thing is not that 5 years ago I was absent and again I am absent today. It is once, my lord, continuous ailment right from 9/7/2018 till 18th of March, my lord, when I have finally resumed. And all these certificates. Here also, my lord, he was a part of this central intelligence officer of the Intelligence Bureau of Ahmedabad. And the allegation was, my lord, that he was absent for 3 consecutive periods for 36 days, 32 days and 234 days, my lord. So, lordship, I am relying on paragraph 16, my lord. Paragraph 16 lordship says that the question whether unauthorized absence from duty amounts to failure of devotion to duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful or because of compelling circumstances. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including circumstances beyond his control like illness, accident, hospitalization, etc. But discussed about the powers of judicial review in such matters.
See, read para 21.
Lordship.
Read the whole judgment.
Lordship. The question relating to jurisdiction
21,
of the
21.
this Bijlani versus
Read para 21 of your judgment as to this one.
the question relating to jurisdiction.
No, 21.
My 21 is if Lordship.
What are you reading from? Read 22. Then something wrong with your printout.
Lordship.
Yes. Read 22. In the present case.
In the present case, the disciplinary authority failed to prove that the absence from duty was willful. No such finding has been given by the inquiry officer or appellate authority.
Now you read this very important part.
Though the appellant had taken a specific defense that he was prevented from attending duty by Shri so-and-so DCIO Palanpur, who prevented him to sign the attendance register, and also brought on record 11 defense exhibits in support of his defense that he was prevented to sign his attendance register. This includes his letter dated so-and-so addressed to Shri so-and-so JD SIB Ahmedabad, receipts from STD/PCO Office of Telephonic Calls dated 29th of September 1995. But such defense and evidence were ignored, and on the basis of irrelevant facts and surmises, the inquiry officer held the appellant guilty.
Let us see the next one. Next decision then.
Lordship. So what I am trying to highlight from this, my lord, is that my absence was as a result of illness and hospitalization as mentioned in paragraph 18.
Yes. Next decision.
The next decision, my lord, is 2008, my lord, 2008, volume 8.
Aye.
469. 2008, Lordship, 8, page 469. This is the case of State of Punjab versus Dr. P.L. Singla, Lordship. It's a leading judgment on this issue. I am only relying on paragraph 14, my lord. Paragraph 14 at page 473, my lord. If I may just read, my lord.
Yes.
Where the employee who is unauthorizedly absent does not report back to duty and offer any satisfactory explanation, or when the explanation offered by the employee is not satisfactory, the employer will take recourse to such disciplinary action in regard to the unauthorized absence. Such disciplinary proceedings may lead to imposition of punishment ranging from a major penalty like dismissal or removal of service to a minor penalty like withholding of increments without cumulative effect. So here, my lord, what is relevant? The extent of penalty will depend on the nature of the service, the position held by the employee, the period of absence, and the cause explanation for the absence. Where the punishment is either for dismissal, so these, so only one line, my lord, what I am trying to show is that the extent of the penalty, my lord, they have the option to give whatever penalty they want to give if they are not satisfied with my explanation or if I have not given any explanation. The extent of the penalty, my lord, will depend on the nature of the service, the position held by the employee, the period of lordship will find at page 628.
Yes.
This judgment is, my lord, with regards to proportionality of the punishment, my lord.
Yes.
Paragraph 15, my lord, was the issue. The question, however, remains, is the punishment of removal grossly disproportionate to the proof charged of unauthorized absence for more than 6 months? In order to answer the aforesaid question, it would be appropriate to refer to few decisions of this court where doctrine of proportionality has been considered. Thereafter, my lord, various judgments of the Honorable Supreme Court with regards to the doctrine of proportionality have been reproduced. Finally, my lord, the finding is at paragraph 19 at page 634, lordship. The court says, the doctrine of proportionality is thus well recognized concept of judicial review in our jurisprudence. What is otherwise within the discretionary domain and sole power of the decision maker to quantify punishment disproportionate to the fault that has been placed, Lordship. And another judgment, my lord, the last one, is of only persuasive value, my lord, where all these judgments have been referred to. And why I'm relying on this, because that was specifically. So the judgment, my lord, I may.
Yes.
I have earlier referred to. And the same finding is there, my lord, that unless and until the allegation of unauthorized absence is proved to be willful and not because of any compelling circumstances which are beyond my control.
One thing, Mr. You have to understand what different from your case with the other cases. These other cases is where the parliamentary proceedings were held and good and sufficient reasons were given for absence. Okay. Sufficient good, I mean good for you that that you hospitalized, and sufficient like for that period.
Gotcha.
Now, when display authority disregards all that,
gotcha,
and says no, then there's scope for interference because the judicial review is so limited.
No, why I'm
so the thing that if you can show that So anyway, I'm not saying that I've not really spoke my mind, but the only thing is that yes, that the only defense is good and sufficient cause.
Yes, my lord. What I'm trying to satisfy is initially before the impugned, the first DP, my lord, the original DP.
So even like they were well aware that you were a scientific case.
Yes, lordship, because they had already drawn up the for absence of 3 months. It is not a case that I have indulged in a corrupt practice or indulged in any my lord act where I have misused my official capacity or something. I was a constable, my lord. Unfortunately, I fell into the trap of alcoholism and. Lordship, I was there and now I have been discharged from the hospital. I am medically fit to resume duties, Lordship, and I am the sole bed runner. That aspect is also there. And
how long will you take, Mr. Vatari?
Hardly 10 to 15 minutes. I don't think more than that, my lord. Or maybe lesser than that, my lord.
I thought there's someone. But in part, let's for you tomorrow. We'll this one open court tomorrow only.
Obliged, Lordship.